the first that I found out that I was being investigated by the Barristers Society would have been 2011. I knew that they were doing a practice review. So 2014, though, is when I actually had formal allegations by the Bar Society. So they began the investigation under the guise of trying to just help with my practice as a young lawyer. I came to find out later that that wasn't their intention, though. Their intention was to collect as much evidence as they can to try to use it against me.
So how did you, sort of interrupt, how did you suspect that and how did you find that out?
So initially, they portrayed it like, we're going to bring in some senior counsel. The senior counsel is going to help give you some guidance. But essentially what the main prerogative of the senior counsel that was looking into my practice was to just take notes provided to the Bar Society and try to find any information that they can to use against me. And so what happened was 2014, after I was initially convicted of some pretty serious criminal offenses, I got the convictions overturned. And when the convictions were overturned, that's when the Bar Society laid some pretty serious charges against me, and initiated a prosecution after I succeeded in my appeal. In terms of part of your question, whether they're true, absolutely I was double booked, but so is literally every criminal defense lawyer in HRM, at least.
So break down what that means by double booking. You're going to be in two places at once in terms of a criminal trial, consulting with the client outside of court?
No, so the main double bookings that I had were, if you go to provincial court, there's 4 or 5 courtrooms within one building. Each of those courtrooms set everybody's matter for like 9:30 in the morning or 1:30 in the afternoon. But obviously there's like a dozen lawyers and dozens of, or at least a half dozen lawyers, and dozens of people that are charged with offenses, all scheduled for 9:30. So obviously everybody's not going to be there at 9:30 and complete their matter at 9:30. So what's common back when I practiced and still today is lawyers will set 9:30 in courtroom 1, 9:30 in courtroom 2, and they'll sort of bounce between the two courtrooms until both of their matters are done. And so when I say literally every single lawyer does this, my wife's a practicing lawyer. She's commonly in multiple courts. She's never been prosecuted or charged with it. And I called, many lawyers during my proceeding to demonstrate that it's common, it's accepted, judges don't have any issue with it. And I'm literally the only person that's ever been charged with it in Nova Scotia.
If everyone does it, how were they then able to successfully, single you out successfully? In that?
Well, we had an all-white panel consisting of Don Murray, who was a practicing criminal lawyer who himself is double booked in the fashion that I've been described as being double booked. We had a Crown prosecutor from the same, or a previous Crown prosecutor, retired Crown prosecutor from the same Crown's office that I laid my suits against. And then the doctor of Joel Pink. That was my 3-person panel, all old white guys. I demonstrated very clearly to them that it's standard practice and it's accepted to be in multiple courts. And they ignored that, singled me out and disbarred me, in part for that, but for other reasons too.